Good morning. Thank you so much for being here. I think we had an advisory board meeting yesterday, and between you all and our advisors, it appears that what we really need is to bring spring to Philadelphia is a healthy dose of criminal justice reform. I want to start this morning by introducing the Dean of the Law School, Ted Ruger, who has taken time out from his own board meeting to come and welcome you all here for our event. So, Ted?
Thank you. Thank you, John. And I really just want to give a brief but extremely enthusiastic welcome to this group and to this this day of the conference. You know, the vision of this Quattrone Center has always been that we would kind of merge the top quality scholarship, rigorous analysis of the criminal justice system and the problems in it with policy impact, with kind of translating that into real world impact that actually helps people and helps improve our justice system. And we are really seeing that come to fruition. The center and its work with the tremendous support of Frank and Denise Quattrone, as well as many others in this room and elsewhere, I think is really hitting its stride. We're seeing tangible outcomes. Judges in key cases involving bail and other issues citing Quattrone Center research, other scholars citing it, you know, this is the best conception of the academy as not a cloistered ivory tower, but as a world of ideas that then translates into policy action and policy reform, and we're really seeing that. I thank John Holloway and Paul Heaton for their joint leadership, and you know, the agenda today kind of is exactly what the center is intended to do. The world of ideas, the world of the most rigorous academic research, and you'll hear from some of these researchers, but very tangible connections to and interaction with the world of our actual criminal justice system. So I couldn't be prouder of what the center is doing or more appreciative of those of you who have been so involved in it. So thank you.
Thanks, Ted. I really appreciate those remarks, and I really appreciate that you did them without notes. I want to thank you all for being here. I'm just going to sort of talk for a few minutes about the concept for the symposium, about the center and its work, and then we'll get into the meat of the day, which I'm really excited about. We've got you know, every year I think we exceed the previous year as far as the range and breadth and depth of our speakers, and we just couldn't be happier to have the agenda that we have today. When we think about complex systems, there are a lot of complex systems that we use every day, and our reliance on those is really predicated on their safety. So transportation is one that we use every day. You don't really think twice about getting in your car. We know that accidents happen, but they're very rare, and rarely do they cause injury. For every 300,000 car trips, there are 2 injuries. And I should say that I'm completely cribbing my colleague Paul Heaton's slides now. So thank you, Paul, for the visual imagery, which as an attorney I am constitutionally unable to provide. For every 300,000 car trips, we experience two injuries. So that's a pretty safe system, transportation. If we think about healthcare, and in particular surgeries, right? Surgeries are fairly dangerous things, but we've worked very hard to make our surgical system as safe as we can. And so for every 300,000 surgeries, there are about 25 quote-unquote never events. So a never event is something that simply can't be allowed to happen. It's operating on the wrong limb, or leaving a medical implement in the patient, or a patient who goes into a healthcare system and comes away with an infection that they got in the facility, things like that. So not quite as safe as transportation, but still 300,000 to 25 is pretty good. Let's play a little Price is Right. Does anybody want to guess what the number is in criminal justice? This is a lot like the way my class starts. There's this uncomfortable silence, and then I keep asking the same question, and eventually somebody comes out with a number. 1,000. Higher or lower?
Higher.
Higher. Who's going to give me a number higher?
30.
30's not higher than 1,000.
30,000.
Oh, 30,000, that's higher than 1,000. Okay. So the true answer is we don't know, which is a problem in and of itself. And we don't know because we don't keep the records, because the feedback loops are late, and because we often don't know when we've made a mistake. But there are a variety of approaches that people have made to try and get at the number. We know from some work done by the National Registry of Exonerations that there are enough There are actually enough death penalty exonerations, and the death penalty population is limited enough that we can do statistical analysis to understand how many times we get it wrong in a capital punishment context, in the most serious, most examined context. And the answer there is 4%. Okay, so 4% of people on death row, statistically speaking, are likely innocent, and the kind of frightening challenge there is we actually don't know who those people are, the 1 in 25 that are innocent, but we know that they are. But we've done some other research that puts that number as high as 8% based on people who have been convicted of crimes, self-reported admissions about whether or not they did the crime. I think a conservative estimate is somewhere in the 2% range, which would mean that for every 300,000 convictions, you've got 7,500 mistakes. And the question that we ask at the Quattrone Center is, why is that number so high? And what can we do to prevent errors? Ben Franklin said an ounce of prevention is worth a pound of cure. You know that that's true because we are here at the University of Pennsylvania, and I am required to mention Ben Franklin every time I make a public speech. So seriously though, litigation is an excellent tool for remediating a past error. Litigation can also be an excellent tool for enforcing accountability and policy, but one of the questions is, what are we going to do going forward? Litigation looks backwards and says, how do we fix something that's already happened? The question we ask at the Quattrone Center is, how can we look forward and put changes in place that will prevent these things from happening again? And I'm going to spend a little bit of time now talking about a British organizational management guru named James Reasons, who has spent a lot of time thinking about complex systems, because the core precept of what we're talking about here is that the principles that healthcare and aviation use to go from however many errors they have to 2 per 3,000 to 25 per 300,000, that we can use those same policies and procedures to make criminal justice bring that number of errors down from 750,000 to something much, much, much more acceptable. Now, Reasons talks about the Swiss cheese model of errors in complex systems. And the way he thinks about it is, think about the criminal justice system as a block of Swiss cheese, okay? But think of the interactions that happen from investigation of a crime, from commission of a crime, through investigation and arrest, through the adjudication of that crime, through sentencing, through post-appellate, incarceration, probation and parole, and re-entry. That's your block of Swiss cheese, and each of those little phases that I talked about is a slice of Swiss cheese. The holes represent the potential for error at each phase. So with every human interaction that goes on in the criminal justice system, and there are many, there is an opportunity for error. Error now defined as something that leads to an unintended outcome. Okay, so their misconduct, which is what we most often think of in criminal justice because our job is to allocate blame. Misconduct is a subset of error, but there are an awful lot of things that happen in the criminal justice system where we either just get it wrong or where we do something that we think is right that leads to an unintended consequence. And it's those errors and misconduct that we're trying to solve. Now, most of the time, in Reason's Swiss cheese metaphor, most of the time, let's say we arrest somebody who isn't in fact the perpetrator of the crime. You've gone through the hole now in your error slice. And most of the time, we'll have a sergeant who reviews that, or a DA at the screening phase, or a public defender who comes up with information on an alibi, or a jury that will acquit that person. And each one of those is a situation where we go through 1 or 2 holes in the Swiss cheese, but then we hit a solid piece in the Swiss cheese and we catch that error, okay? But sometimes all the holes in our Swiss cheese line up. Sometimes something goes wrong at each phase of the system. Now, in aviation, that's a plane crash. In healthcare, that's a never event. And in criminal justice, that's an inaccurate conviction. Okay? Those are the things, the sentinel events that happen when we get errors all the way through our system. But those are also wonderful learning opportunities, because what that means is not only did we have an error that we can learn from, but all of the existing checks and balances in our system likewise failed to catch the error. And so there's a shared opportunity for all of us to learn together how to reduce these errors. And so we'll convene people, bring them together, and think about these, whether they are unsafe acts or preconditions for those acts that allowed them to happen, or failures to supervise, or organizational influences that lead us in directions we don't want to go. And so that's the Swiss cheese model. And Reasons has supplemented that Swiss cheese model with 12 rules, of which I'm going to highlight 4 today. This is Dr. Reasons. Rule number 5, People cannot easily avoid those actions that they did not intend to commit. Blaming people for their errors, as opposed to misconduct, blaming people for their errors, those that they did not intend to commit, is emotionally satisfying, but remedially useless. Now, any of you who are parents has some sense of what I mean. It's very difficult to train a child not to spill a drink, right? Because the child doesn't intend to spill the drink. So it might be emotionally satisfying in the moment to shout at your kid, hey, why'd you spill that orange juice? And to the extent that your child intentionally went on to the expensive Oriental rug and spilled their orange juice where you had told him not to go, there's training that you can do there and supervision that you can provide there that might prevent that. But fundamentally, punishing a child for spilling a drink is not going to be useful unless the child turned the cup over in defiance, right? There has to be intent, and deterrence and punishment is only going to be effective to deter intentional misconduct. In every industry that has studied it, misconduct outweighs error 20 or 30 to 1. There's a lot of emphasis on misconduct in the criminal justice system, and there should be. There's a lot of concern about whether we have the right aligned incentives, and there should be. But it's really important that we focus on error, because error is going to outweigh misconduct in terms of the number of things we do. And when we reduce errors, we shrink the holes in our Swiss cheese, and we make it harder for people to get away with misconduct. So by dealing with error, we also deal with reduced opportunities for misconduct, and we take away people's belief that they can get away with misconduct. So we can actually achieve both by working on the actions that people didn't intend to commit that nonetheless led to error, and putting a hold on the emotional satisfaction of blame in favor of something that's a more useful remedy. Reasons is rule number 3. You can't change the human condition, but you can change the conditions in which humans work. We can't change the fact that people are going to make mistakes. That's the human condition. We can't change the fact that people are going to think that one thing is good and then have it go in a way that they don't anticipate. What we can do is change the environment to force decisions to be made in a different way. And the reason I've got an ATM machine up here is, I don't know about you guys, but there was a time in the 90s when I would leave my ATM card in an ATM machine about once every quarter. And the reason I would do that is because what I was really focused on was getting my money out and going out with my friends. And so I would get my money and I would walk away from the machine, and the machine would then take my card back, and then the bank would have to send it someplace else, and then it would take 2 weeks for me to get my card back. And it was good that I had a lot of cash at that point, because I wasn't going to have an ATM card for a couple of weeks. That doesn't happen anymore. And the reason that doesn't happen anymore is that PNC Bank and other banks got tired of having to deal with the fact that everybody was leaving their ATM cards in the machines, so they've changed the system. Now, you actually can't get your money until you've taken your card back in most ATM machines, okay? So they didn't change the human condition. What they did was recognize that what people was focused on was getting their cash, not their card. And so they changed the sequence of events. They changed the environment in which people were working. Say, get your card, and then I'll dispense the cash, and nobody walks away from their cash, right? Those sort of environmental solutions are going to be much more powerful in a situation where people aren't intending for these errors to happen. And that's the challenge for those of us who are trying to improve the criminal justice system, is to try and improve the structure of it. And that's the topic of a lot of our conversation today. Reasons rule number 6. Errors are consequences, not causes. Only by understanding the circumstances around the error can we hope to limit the chances of their recurrence. Now, I used to tell this story about Tom Brady, but we like winners here in Philadelphia. And so I'm going to tell this story about Nick Foles, and I think it holds really for any NFL quarterback. The fact of the matter is, whatever you might think of an NFL quarterback, he's one of the best in the world at what he does, okay? NFL quarterbacks are talented, well-trained, well-coached, practice these things all the time, and they know exactly what play they want to run at any given time. But it turns out that when you get 22 guys on a football field and you yell hike, all sorts of stuff happens, okay? And you've got to deal with the field conditions, and you've got to deal with somebody slipping and falling, and you've got to deal with a coverage that you didn't recognize, and you've got to deal with somebody doing something that they weren't supposed to do. And in all of that hullabaloo, a quarterback makes a decision and throws a pass. And he thinks that that pass is the best thing that he can do at that moment in time. And sometimes that pass gets intercepted. It never gets intercepted because the quarterback wants to throw an interception. It happens because the data that the quarterback is processing in a dynamic and imperfect environment leads him to believe that a certain choice is the best thing he can do, and then it leads to an unintended outcome. The analogy from that to a criminal investigation or a criminal trial seems very, very clear to me, and I hope to all of you. It may be that the thing to do is to bench that quarterback, but you're not really going to know that until you sit down and break down the video moment by moment and ask that quarterback what he saw and thought and felt and believed was going to happen. And that's when you understand the circumstances around the event. The interception is a consequence, not a cause. The question is what caused the interception and how do we modify that cause to reduce errors going forward. And the last one, reasons rule number 12, effective error management aims at continuous reform. We're not going to get there by killing the mosquitoes one at a time, okay? We're going to get there by changing the environment so the mosquitoes can't continue to breed. And what we're going to have to do then is remain vigilant so that the mosquitoes don't come back. Doing these things that are little idiosyncratic fixes are not going to get us there. We have to do broad systemic restructuring. And that's what Reasons' point is and why we're talking about the title of today, Reforming Criminal Justice. Now, in terms of healthcare and its making its environment safer, this is a chart. I started by plagiarizing my colleague, Paul Heaton. I'm going to finish by plagiarizing my colleagues at Penn Med. This is a chart that they use to teach their surgical teams about proper responses to error and making the surgical environment safer. And what they have here are the types of responses to error, and they've separated them into high impact, medium impact, and low impact. And I've highlighted the low impact ones because when we respond to root cause analysis, when we conduct these in criminal justice, and when we meet with people about solutions, very quickly and very easily people go to education and training, policies and procedures, double checks, and documents. And those are all useful solutions, but it's important to realize that those are not the solutions that we see in the ATM example, right? We haven't changed the environment in which people are working there. We haven't slowed down decision making. We haven't created a situation where forced incentives are forced. And if you look at the high impact things, anything we can automate takes human decision making, human error out of the equation. When we can force functions so that it's very, very clear what people are supposed to do, or that they're unable to make a different decision, and we can drive them in that way, that's better. Fail-safe mechanisms, wherever we can implement those, and then standardizing equipment and improving physical plant. I know that we talk to DAs and public defenders all around the country whose information architecture and information infrastructure is antiquated, and they can't get the information out of it that they need to be able to create some of these things. If we change, how many Brady violations are records management problems as opposed to intentional violations? Actually, we don't know. These things are problematic. So there are systemic things that we need to think about. But what I would challenge everybody in this audience to do for the next day and a half while we're together is to consider, as we talk about reforming structures in criminal justice, how many things we can do that are forcing functions or automations or fail-safe mechanisms in which we can change the environment in which people operate. As an example, I wrote a book about an exoneree named John Thompson. John was incarcerated for 18 years in large part because a lab report, a blood test that had been conducted on him made it to the DA's office, but then never made it on to the defense. Okay? And without that information, John was unable to successfully argue his case for his own freedom. When that blood test came out, it exonerated him and he moved on. If that had happened in the District of Columbia in 2013, instead of in New Orleans in 1985, John likely would have had a very different result. And the reason is that in the District of Columbia, their lab, which is separate from the police department, is required by law to send 2 copies of all tests to the prosecutor or the orderer of the test. 1 copy is for the prosecutor, and the other copy has a big red stamp on it that says, "For the defense." Okay? What the lab has done is they've changed the environment in which those prosecutors are working. They've created a forcing function in which they have a very obvious, clear obligation of the prosecutor what that prosecutor is supposed to do. This does 2 things for us. First, for every prosecutor who is inclined to follow the rules, and I still believe that is the vast majority of prosecutors, they have a clear instruction about what the rule is. Second, if a prosecutor now does not follow the rules, it's become very clear for us to know whether that is error or misconduct. Because in order for a prosecutor not to have followed the rules in this situation means that they have ignored the bright red sign that says you are to give this to the defense. And that makes our observations clearer and the remedy that we can do for that problem clearer as well. So I'd like to talk a little bit about the rest of the day. We are, a 21st century technology-driven center, so we do have a hashtag, hashtag Quattrone Symposium 18. We are live streaming the event, and we'll be moving forward all day with that, so we encourage you to tweet and post and do the apps. You will see that there are index cards in front of you for each of the panels today. As you think of questions, please write them on the index cards. As we get 2/3 or 3/4 of the way through, there will be assistants who come by and collect your cards, bring them up to the moderator so that we can handle that in the Q&A period. And we'll have coffee and water outside, and wireless and other things are, I think, in your packet. The agenda is really exciting for today. We're going to talk about reforming criminal justice investigations. We have Howard Root with us, who's the author of a book called Cardiac Arrest, 5 Heart-Stopping Years as a CEO on the Fed's Hit List. We'll talk about public defense and what we can do to reform the structure there. Criminal record history. What can we do for people who have paid their debt to society to facilitate their ability to then function fully in that society once their debt is paid? And then we'll talk about prosecutorial reform. And then just as a matter of courtesy, we thought we'd give you guys some drinks at the end. With that, I would like to invite our first panel to come up to the stage. I'm going to let Amanda Bergold introduce the speakers, but I'd like to introduce Amanda, who is one of our Quattrone Research Fellows. Amanda joined us 2 years ago from John Jay, where she got her PhD in social psychology. She is a national expert on eyewitness identification and has published extensively on the role of eyewitness instruction jury rules on juries. She's currently doing some fascinating research on the role of facial recognition databases. And I have to say, I'm really excited for this panel because a lot of times when we talk about preventing errors in criminal justice, we're talking about how to keep officers or prosecutors or other people on the law enforcement side of the ledger from making mistakes. It's rare that we have opportunities to talk about how we help them improve accuracy as opposed to reduce error. And the conversation we're going to have today is, I think, a very positive one, because this is one where we actually talk about how do we help people get it right more often instead of how do we prevent you from getting it wrong more often. So I'm really excited about the positive nature of this to make the criminal justice system better and more accurate, make sure we get the right guy in the right way. And let me turn it over to you guys.
Well, thank you, John, for that introduction. As John mentioned, I'm a fellow here at the Quattrone Center, and I'm really excited to be to introduce our panelists for our panel, Reforming Criminal Justice, interviewing witnesses and suspects. So today with us, we have Dr. Ronald Fisher, Colonel Stephen Kleinman, and Dr. Christian Meissner, and I'm going to offer some more thorough introductions of their backgrounds after I introduce the topic. So the number of false confessions that have contributed to the DNA exoneration cases from the Innocence Project highlight the importance of improving the techniques that investigators use to interview suspects. The data from empirical research and from DNA exoneration cases demonstrates that these interviewing techniques can actually contribute to the creation of unreliable information. In fact, all 3 members of this panel, in addition to some other authors, recently contributed to a critique of what is known as enhanced interrogation methods and offered some psychological perspectives on the use of torture, cruel and inhumane treatment, accusatorial and psychologically coercive methods, and their critique mainly states that these methods can actually negatively impact the information provided to investigators. And while a lot of the police training on interviewing has focused on interviewing suspects, interviewing witnesses and victims is a really important aspect of police investigations and can provide really valuable information about the event, and we know that the questions that investigators ask can actually influence witnesses and victims' memory for events. And we are really fortunate. I'm going to start by introducing Dr. Ronald Fisher, who is the pioneer of the method, the cognitive interview. Dr. Ronald Fisher is a professor of psychology at Florida International University. He's a research psychologist who has performed research in the areas of investigative interviewing and pioneered, of course, the cognitive interview. In his work on the cognitive interview, he's really focused on the role that memory plays in improving the memory of witnesses and victims. He has authored over 100 peer-reviewed articles, I hope that's right, and trained many investigative agencies in his interviewing techniques. His book on the cognitive interview that was published in 1992 is sort of the gold standard for training books dealing with procedures for victims and witness interviewing. He has conducted numerous training seminars on eyewitness memory and investigative interviewing to federal, state, and local agencies in the U.S. and those abroad as well. Some examples of the agencies that Dr. Fisher has worked with include the FBI, the National Transportation Safety Board, NASA, the U.S. Army and Navy, the British and Australian Police, and the Israeli Air Force. He's also the editor of the Journal of Applied Research in Memory Cognition, and he was a member of the National Institute of Justice Committee to create the national guidelines on eyewitness evidence. I'm going to introduce Christian Meissner. Dr. Christian Meissner is also a research psychologist at Iowa State University. He has performed research in the areas of false confessions, investigative interviews, and issues surrounding eyewitness recall and identification, and deception detection and interrogations. He has published more than 80 peer-reviewed journal articles and received over $15 million in grant funding. His research has been supported by the National Science Foundation, the U.S. Departments of Defense, Justice, and Homeland Security, and the U.S. Intelligence Committee. While Dr. Meissner's work covers a variety of fields, the one we're going to focus on today is his work developing effective science-based methods of interrogation. And he has developed extensive collaborative relationships with major training academies in the United States to experimentally compare science-based methods with existing practices. He's going to talk a little bit also about his work working with the FBI's high-value detainee interrogation group, known as the HIG, which I always have trouble remembering the full name of. And last but certainly not least, we have Colonel Stephen Kleinman, who is a career military intelligence officer and a recognized expert in the fields of human intelligence, strategic interrogation, special operations, and special survival training. He has been widely recognized as one of the most effective and prolific interrogators in the Department of Defense. He served as an interrogator, the chief of a joint interrogation team, and as a senior advisor on interrogation to a special operations task force during Operations Just Cause, Desert Shield Storm, and Iraqi Freedom, respectively. He was formerly the director of the Air Force Combat Interrogation Course. He also served as the director of intelligence at the Personnel Recovery Academy, a unit of the Joint Personnel Recovery Agency that serves as Department of Defense agency responsible for overseeing survival, evasion, resistance, and escape training for U.S. military personnel. He was also, I just found out, awarded a really prestigious award, the Defense Superior Service Award, on his retirement from his military service. He has also been featured on CNN speaking about his opposition to torture, and has been featured in such newspapers as Newsweek and the Washington Post. So I'm going to start with asking each panelist to sort of introduce themselves, their backgrounds in research, pursuing research and interviewing, and let's start with Dr. Ron Fisher.
Thank you. It's nice to be here. It's always a pleasure to work with smart people who are interested in improving society. I noticed the photographs that we had before. It's nice to see what we all looked like from 20 years ago. So my background is as a cognitive psychologist. I was primarily interested and trained in memory and attention. And I had a visiting scientist position at UCLA at the time. And I had a few related experiences where friends of mine would forget where they placed an object. When I spoke to them, they were often able to remember things that they couldn't on their own. So I spoke to one of my colleagues, Ed Geiselman, who had done a lot of applied research about who could use this skill of helping other people to remember. And his immediate response was police, because police are always interviewing witnesses, and that's essentially how police solve cases, that they get information from witnesses. It's not like what you see on CSI. Those are rarely the exotic kinds of facilitators. So Geiselman and I went to the Behavioral Sciences Division of the Los Angeles Police Department to find out what kind of training do you provide to police for interviewing cooperative witnesses. And they looked at me like I was crazy. Why do you need to provide training for interviewing cooperative witnesses? We provide training on interrogating suspects, but if you want to know how tall was the guy or did he have a gun, just ask how tall was the guy and did he have a gun, and was he black or white or Hispanic or Asian? Why do you really need training? So I thought that was odd, given that eyewitness information is so important, but they received no training on interviewing cooperative witnesses. And I probably shouldn't have been, because if you look across domains among people who are investigative interviewers, as for example, you're a physician, when you go to your physician asks you a question. Your physician is not trained on interviewing patients. They're trained in biochemistry, they're trained in physiology, and they're trained in anatomy. What you find is that all of these people who are doing investigative interviews, as for example with the National Transportation Safety, but they're all trained in content. That is, they know what to look for, and so they direct questions at each particular piece of information that they want to look for. So your physician asks you about the medication that you've been taking, and the NTSB investigator asks pilot, what was the speed of the plane? And the police officer asks about, was the person black or white or Hispanic or Asian? And they think in terms of content, and they don't think in terms of process. How do you actually get this information? And they just assume that if you know what to look for, it should be relatively easy to get that information. And they don't really think in terms of, maybe people have problems actually remembering in detail. So that was our goal then, initially, was to take what we know about memory, which is one of the oldest areas of cognitive psychology, and then to adapt it to a face-to-face interview with cooperative witnesses. And we called it the cognitive interview because it's based on principles of cognition. And we had done several experiments, all of which showed that if you ask people questions about what they experienced in terms of memory-enhancing principles, that not surprisingly, they will remember more than if you just fire off a bunch of questions, which is more characteristic of what police do. After having done that maybe 4 or 5 years and reviewing the interviews that we had conducted in the lab, but also listening to interviews that were conducted by police, we had tape recordings of police interviews, it soon became obvious that this was not just a problem of witness memory. That is, there are also issues of social dynamics. What's the interaction between the police officer and the witness? And what about problems of communication? So I know exactly what my wife's face looks like, but I can't describe. I'm just a normal face. I just don't have a vocabulary for describing faces. So if you're interviewing me and I have a good memory of my wife's face, you have to do something that will assist me to communicate my knowledge to you. It's not simply a matter of asking me, what does your wife's face look like? What does the criminal's face look like? So we modified the cognitive interview to take into account not only memory issues, but issues of social dynamics and issues of communication. But it's not only a problem of the witness. It's also the interviewer has to keep track of a lot of information. So the interviewer has to keep track of, what's my next question going to be? What did the witness just tell me? What's my hypothesis about how this crime occurred? How could I notate everything? So the cognitive interview then became much more complex. Let me give you what I think is one of the critical elements on the social dynamics. You have an interchange between two people, one of whom is knowledgeable, namely the witness, and one of whom is literally ignorant in terms of not knowing, but curious. So you think that the knowledgeable person, namely the witness, would dominate that conversation. The problem is that the interviewer typically has more power, social status, than the witness does. And so typically what happens is that the witness defers to the person with power and allows the police officer to control the interview, and the witness takes as his or her task, I will try to answer the questions being posed by the interviewer. So you now have a bizarre situation where you have somebody who knows the least amount of crime controlling the interview, and the witness's memory is being directed by somebody else. I mean, I would think that I can direct my search through my memory better than you can direct me to search through my memory. But that's what typically happens in a police interview. The police officer controls the interview because the police officer has power, and it's a very, very inefficient way to get people to remember. You get virtually no unsolicited information like that because the witness takes as his or her task a question answerer. So if you don't ask me a question, I will not provide that information for you. So we revised the cognitive interview then to include issues related to memory, issues related to social dynamics, issues related to communication. And that's more or less the current version of the cognitive interview, which has been very successful. Typically, we get somewhere between 25 to 50% more information from witnesses. Those are in controlled laboratory studies. We have one field study with the Miami-Dade Police Department. So we trained some members of the robbery division on this cognitive interview. We had other experienced police officers, robbery detectives, who are not trained, and we found that we're getting around 50 to 60% more information with the trained people than with the untrained people, and also with the trained people after training than before training. So we have a lot of good evidence. Is now probably including everybody who's done research on this, and a lot of people in England and Canada and Australia. There are probably about 110, 120 experiments now on the cognitive interview. So we know that it works, and Chris could probably tell you more than I about, because Chris has done a meta-analysis on the research. So we have very good evidence that it works, but it works because it's process-oriented. It's concerned only about what are the psychological processes that interviewers and witnesses go through when they talk to each other. If it's based only on psychological processes and has nothing to do with crime itself, then it ought to be useful for pretty much any kind of interview, as long as you have one person who's curious and another person who's knowledgeable. So we would expect that the cognitive interview should be able to expand to things like accident investigations. It should be able to expand to things like recalling meetings that one had. I'd be very interested to get involved in some of the Mueller investigations, because some of those are going to be about meetings that people had, and those meetings occurred a while ago, so there are going to be issues related to memory. But even within the criminal investigations, so you'll have debriefings of police officers who are involved in shootings. Who's doing those debriefings? There are other police officers who are also knowledgeable about content, but they haven't been trained in the processes associated with how do you get information from the police officer. You have decisions that people made, whether to shoot or not to shoot. You have decisions within the police department. You have decisions within legal groups about how should we try this case. And then if the case is not tried very well, presumably somebody's going to ask the attorneys, well, how did you make this decision? So we've adapted the cognitive interview then to getting people to remember how they made decisions, in addition to trying to get information about external events. So we've had, a lot of interest in doing this. We've been reasonably successful. Probably the most satisfying part is that we actually contribute to society. And it's based on a lot of very, very good scientists' work, some of whom are sitting on the panel here. So that's pretty much an encapsulation of my life. Oh, of my adult life. You don't want to hear me about being a shortstop.
Right now, I'll ask Colonel Kleinman the same question. To give us a little sense of your background.
Question, how does a military intelligence officer end up at a conference talking about reforming criminal justice? Excellent question. Like everybody else who's ever served, not just in the military, but in government service, you take an oath to support and defend the Constitution of the United States against all enemies, foreign and domestic. So my focus for 30 plus years was enemies that were described as foreign. Not realizing at home, we have a great deal of problems. And a lot of wicked problems, a lot of social problems, many of which are related to or directly involved with the criminal justice system. And through a number of propitious events, I ended up having the opportunity to work with American law enforcement in examining how they go about their work. As an intelligence officer, my background actually, before I was an interrogator, I was a clandestine case officer, so recruiting assets overseas. So I approached this, I think, in a little bit more sophisticated way than the average military interrogator. I thought about it more as a seduction, as a recruitment, as opposed to something that you could force out of people. I was just thinking, literally just before we came up here, one of the most influential experiences I had was right out of graduate school. Before I joined the CIA, I started my career there, and before I transitioned to the Air Force, I was actually a probation officer for about a year. And I heard in a year more lies than the average person will hear in their lifetime. Now, I say that not with a cynical tone, at least I don't want to come across that way, because for whatever reason, I believed most of them, which meant if I believed them, it meant I listened to them, and that there were certain expectations of that belief. If somebody said that they were going to alcohol counseling, or if they said that they'd paid their restitution, or they were looking for a job, I really believed they were. What I didn't know was how influential that would be in decades later studying deception. We look for all these nonverbal behaviors, when in fact it's the information. It's people that are telling you the truth, they have lots of details because their memory is often clear and exact. But if you're fabricating, those details get very, very murky very quickly. So again, that led through my experience with military intelligence and realizing very quickly how unsophisticated our approach was. With the global war on terror, you would think, here we are in the 21st century, that with 21st century intelligence technology, that perhaps interrogation, which can date back to antiquity, would be no longer valuable, when in fact we find it was essential, it was central. Some of our adversaries were using antiquated, if you will, traditional means of communication that weren't accessible by signals intelligence. So we all agreed that interrogation was very, very important in this new 21st century conflict, but yet we approached it in a way that was consistent with World War II level understanding of how you interrogate. So we had 70 plus years of tradition, absolutely unhampered by progress. And you think about, to my right and left, I have actually, and also at the end of the table, all three of my colleagues here are psychologists, behavioral scientists. And if I asked them to give just a 5-minute overview of the advances in our understanding of human behavior since World War II, we'd be astonished. But yet, again, the underlying technology, if you want to call it, the foundational philosophy that underpins, for example, the Army Field Manual on Interrogation, which, thanks to the National Defense Authorization Act of 2016, specifically the McCain-Feinstein Amendment, shapes how we conduct interrogations on the federal level. But yet there's an interesting element of that Army Field Manual, again, that has never been examined objectively for its validity, for its efficacy. The informal examinations that we've conducted, many of those strategies are not just ineffective, but sometimes counterproductive, but yet they're used over and over again to help facilitate this information that drives military decisions, political decisions, strategic decisions. Now, how does that work in the criminal justice world? I found that there's a very similar obstacle, and that is what we call conventional knowledge. There's a lot of tradition about interrogation, and of course a lot of that tradition is shaped by the media. I mean, who here has not seen a fictional portrayal of an interrogation on television or in the movies? We all have. And unfortunately, that really literally has shaped, it's promulgated an ineffective model. Like it's forcing versus fostering. And people just assume that you can force information. Now, the question is, where's the information reside? Dean Holloway set the stage, so we'll ask the question over and over again until we get an answer. Where does information reside when you're talking about information that somebody might possess? It's their memory. It's their memory. So if we're after information, whether it's in intelligence context or law enforcement context, the most important task we have is to facilitate the best possible recall. Rather than interrogate, rather than interview, we could describe ourselves as memory facilitators, because that is what we're after. Since I'm here and identify as a military officer, I have to use my obligatory Clausewitz quote. But the grand strategist Clausewitz talked about the most important task of the general is to identify the war they're in and not make it any other than it really is. And so we need to do the same thing. What are we here to do in terms of interviewing? And that is to facilitate the best and most complete recall of events, to provide an objective means of assessing credibility, of detecting deception, of understanding why deception occurs when it does. Because at the end of the day, if you're talking about procedural justice in the criminal justice system, people want procedural justice no matter who you are, no matter where you come from. If you have an interaction with the criminal justice system, you'll be treated fair and equitably. And so that is based on the quality, the fairness of the information that is obtained. And that comes from the fairness of the interview that's conducted. And ultimately, that is shaped by how fairly you're able to help somebody recall. Now, if forcing was helpful, Chris has heard me say this several times, then I could start my own tutorial program and guarantee success academically, because if you're having problems recalling, let's say in an exam, I could scream at you, I could put you on a regimen where we kept you up for days, we manipulated your circadian rhythms. We know what happens. I mean, you wouldn't be in this room if you didn't succeed to an extraordinary level in your academic careers. But you still remember, no matter how prepared you are, those exams, that anxiety, that's also part of the interview. And that's this anxiousness that we encounter. For some reason, anxiousness during an exam, a professor sitting in the front would say, well, they've prepared hard and their performance is very important to them. But if we took the same behaviors and we transferred that to you're an innocent person wrongly accused of a crime who's doing their very best to recall, to answer the questions correctly, we see a great deal of anxiety. And suddenly, what do we say? That they're guilty, that they're lying. And thankfully, again, because of behavioral science, we know that's not the case at all. These anxiety-based cues aren't useful. But again, going back to my military experience, lots of memory. There's an assumption that what happened 5 years ago is easily recalled as something that happened yesterday. And that's what informs it. So I've had the unique opportunity to see a lot of failures. If failure is the stepping stone to knowledge, then I suppose I'm a genius in that respect. But I see opportunities too. And I've had a chance now to work with law enforcement at the federal, state, and local level. And I've been extremely encouraged by a number of agencies who are reaching out, who realize that the status quo isn't good enough. The status quo is actually causing more problems than it's solving. I'll call out Los Angeles Police Department. There's some groups there that now when they go in to do an interview, they are just as excited about being the person that got the information that exonerated somebody as much as it used to be to get a confession. And let me conclude my remarks with this. Dean Holloway put up a great slide about complexity. And Chris and I, when we talk a lot about interrogations, we think about it that way as a systems approach. And the key is what we learn from systems theory, that what shapes the system is the objective. You change the objective, you change the system. So if your system is designed, and now we're talking specifically about interviewing and interrogation, but if your system is designed to get a confession, then you're going to take a series of steps to achieve that goal. In contrast, if your goal, if your objective is to get the fullest possible truth, to elicit cooperation and the fullest possible disclosure, that requires a completely different system, and that system needs to be shaped by a deep and abiding understanding of human behavior, which again, why working with behavioral scientists for the last decade, for me, it was sort of like being in a small car crash. You know, it takes a while for your head to clear, and then you realize how little you knew. But I think there's a lot of hope. But everything that goes on in criminal justice, almost everything, has some connection with how we're interviewing and the information we're getting from people, whether it's a suspect, whether it's a witness, whether it's a victim, whether it's somebody testifying in court, whether even if it's somebody picking out an individual thought to be guilty in a lineup. So I think I'll leave it at that.
Thank you. Dr. Meissner?
Good morning. Thanks for inviting us. I'd like to say I'm a disciple of Dr. Fisher, and I was recruited by Steve Kleinman. I actually started my academic pursuits with the goal of law school, and I finally made it. Thanks for inviting me. But along the way, I found psychology, and I think I found my interest and my passion and the way that I could contribute. Just as a bit of background, I actually came from a criminal justice family, not a crime family, but a criminal justice family. My grandfather was a police officer, Clearwater Police Department, Florida. Made it to sergeant before he retired. My father made it all the way to captain at the Clearwater Police Department before he retired. Then he went on to be an investigator for the state attorney's office. My uncle, my father's brother, went to law school, was an FBI agent, was a state attorney, and now he's in private practice. And so out of that, I came with a deep interest in law and making a contribution, making a difference. But somewhere along the way, I mean, serendipity happens, and as an undergrad, I fell into psychology, and then I had an opportunity to take a course on psychology and the law. And in fact, the professor who was a new professor at the time had approached me about my interest in taking such a course, and I said, well, what's psychology and the law? I mean, I wanted to go to law school at the time. This sounds fascinating. I would love this opportunity. And so she had a seminar. There were 5 of us, undergrads. She taught it like a graduate seminar, and it completely changed my worldview and changed my direction, my heading. And I ended up in grad school and got a degree as an experimental psychologist. For the first decade of my career, I studied wrongful conviction issues, the kind of issues that we're here to talk about and that you know very well. So from eyewitness identification to false confessions. And what was interesting were the conversations that I would then go on to have with my father, who was still a cop at the time. And around the dinner table, we would talk about some of the research that was happening, I was contributing to, and others. And, they would go something like this. Hey, Dad, why are you guys doing this, right? Why are you conducting investigations this way, collecting information this way? Why are you interrogating people in ways that bring about false confessions? Well, why don't you just stop doing that? And my father would look at me very, very nicely and say, well, that's really great, son. I really like your research. It's really interesting. But what the hell else would you have us do? What's the alternative? What would you rather we do? What you've said to me is, we can't do this, we shouldn't do this, you really can't do that. And, oh, by the way, would you videotape so that we can make sure that you're not doing these things? You haven't given me a viable alternative. And I came away from that conversation challenged, because I didn't have anything to offer him at the time, right? We knew cognitive interview, a very successful interview approach applied to cooperative witnesses. We didn't have those alternatives in the interrogation context. And so for the second decade of my career, I've focused on building a better model. looking at evidence-based approaches to changing the way that we conduct interviews and interrogations, with a focus on achieving what I call diagnosticity. Can we improve the value of the evidence or the information that comes out of a suspect? Can we increase the likelihood that we get good information, confessions, if that's the goal, from guilty suspects, and that we're also able to separate the guilty from the innocent? That is, we have techniques that clearly discriminate between the two. A number of years ago, the issue of torture came up, and of course this was an issue that really informed my passion to find alternatives. What Steve is modest about not mentioning here is that he was part of a study, a very important study, called Adducing Information. And it was a study that was put out by the Intelligence Science Board, 2006. It's, by the way, on the web. You can download this study. A group of experts got together from the intelligence community and other communities and essentially reviewed the state of knowledge on how we interrogate people, both from a military intelligence context, but also from a law enforcement context. How do we train interrogators? What do we know about the efficacy of that training, the effectiveness of that training? And in fact, that report, I think, was pivotal in really changing the way that our government thought about interview and interrogation. Out of that report were a number of recommendations and a number of critiques, which is essentially the critiques that have been offered to date. That in fact, we've been doing interrogation in the criminal justice field and apply that to the Army Field Manual, which hasn't really changed in the 50 plus years. Interrogation training in the criminal justice field hasn't changed in the US in 60, maybe even 75 years, if you look back to one of the first manuals that came out after the Wickersham Commission and the changes from third-degree tactics to more psychologically based tactics. There have been reforms in other countries, and we can look to other countries for models. The UK reforms are instructive and useful in that context. And the UK actually responded to the problem of false confessions very differently than the US has. When they had a number of high-profile cases in the 1980s, it ultimately led to enacting some reforms that essentially prohibited the use of psychologically coercive or manipulative tactics and moved law enforcement to be trained on what might be called good elicitation tactics, good interview tactics, and ultimately to the development of what's called the peace model today. And the peace model has been effective in reducing the likelihood that we see wrongful conviction due to false confession, reduces the incidence and likelihood of a false confession. And it seems to have also preserved police's ability to collect confession evidence and statements that are admitted into court and lead to conviction, good convictions. The US didn't respond that way to the problem of false confessions. In fact, we're still offering the same kind of training that's been offered over the years. There are a number of training institutes that are out there that offer this training to state, local, federal levels. And they're very resistant to the critiques that are offered by the academy and any opportunities to change. Well, when Obama came into office, one of his first executive orders was to prohibit the use of so-called enhanced interrogation and to set about a process, a commission by which they would study the problem of detention and interrogation. About 9 months later, that commission came back and recommended the establishment, the creation of an interagency group, what's referred to as the High Value Detainee Interrogation Group, or HIG, the acronym HIG. The HIG's mission is to conduct interrogations on high-value targets, largely in a counterterrorism context, both overseas and in the US, wherever that may be. And it's ultimately, its intent is to bring together the best interrogators that the US government has to fulfill that mission. It also, though, has a research mission and a training mission. The research mission is to both evaluate existing practice and to develop new interrogation approaches that are ethical, legal, and evidence-based. And the training mission is to take from that research and train not only the Higg interrogators, but to share that knowledge with training academies across the US government. Steve and I have been involved with the Higg since its inception. Steve is currently chair of the research committee. Ron and I were some of the original researchers that have been part of that, and we've been continuously supported by the Higg, fulfilling its mission. Over the past eight years now, the Higg has funded 35 plus different research groups, not only in the US, but around the world. It doesn't place restrictions on those researchers. Those researchers conduct research at institutions of higher education, universities. They also conduct research in the field where appropriate. It's all overseen by human subjects committees, ethics reviews, both at the university level and also the FBI oversees ethics as well. And the faculty, the researchers are not prohibited from publishing and publicly disseminating that work. In other words, it's completely unclassified and contributing to the academic literature. So at this point, I think the researchers that are associated with the Higg have published now more than 130 publications on the work that they've done that's accessible to the public and the academy and practitioners. What's really great about this program is that we've also had an opportunity to work with practitioners. So one of the studies that Ron didn't mention, one of the kind of quasi-field experiments that he did was to work with the Federal Law Enforcement Training Center, FLETC, in Glencoe, Georgia. And as part of that, he had an opportunity to kind of train and evaluate trained and untrained people using a cognitive interview approach versus, I'm stealing your lines here, Ron, because it's a great study, what I like to call the FLETC five-step dance, but the FLETC five-step method, which is a good interview protocol, right? Good trained interview protocol. And Ron can help me get this right, but I believe that the cognitive interview elicited more than 80% more information than the FLETC method. Through the process of doing studies like that with the training cadre at FLETC and other training centers, we've actually converted the trainers to be proponents of the science. That is, they help us design that experiment. Ron worked very closely with them to develop that, to conduct the experiment at FLETC, to compare their method to the cognitive interview in a rigorous way, and the results speak for themselves. And now we're at a point where, in fact, FLETC just recently, FLETC is a multi-agency, they contribute to the training of multiple agencies. I think 90 plus law enforcement agencies they contribute to at the federal level, just at the federal level. And their training curriculum is actually developed by consensus of those partner organizations. So they have these committees that get together to decide what the training is, and particularly if there's significant changes to the training. Well, they just recently had a conference review where the training cadre in the Behavioral Science Division proposed moving the training on interview and interrogation to a science-based model of interview and interrogation, and adopting the recommendations of researchers and of the Higg itself in what is effective practice. And those partner organizations agreed. And so we're starting to see, as a result of this, shifts not only in the science, and I usually have a graph that I can kind of show you the rise in publications each year on these topics. It's significant, and has been significant for the past 8 to 10 years. I attribute much of that to the Higg. But we're also seeing changes in the way that practitioners are being trained. And we're starting to now get calls because that understanding that things are changing is seeping down into the state and local levels. And so it wasn't, was it 12 months ago now? Steve and I both had an email in our inboxes And wouldn't you know, it was from Major David Dalton from the Clearwater Police Department. That sound familiar? The department where my father served for more than 30 years, my grandfather before that, and my uncle for a short period of time. David actually didn't know that my father or my family had a history with Clearwater. So there was no connection. It wasn't as though he was reaching out to me as somebody in the know. But they had heard about the Higg research, and they wanted the Higg training because they had had an incident where there was coercion in an interview context. And they realized, the chief realized he needed to make a change. And he learned about this because all of the research and our discussions about this are public. The Higg is a proponent of sharing. And so we've now had an opportunity to do 2 trainings down in Clearwater and beginning to reform the way that they do interviews and interrogations. And there are other agencies that are coming in for the training as well. It's beginning to change. We're beginning to see shifts in mindset and in receptivity to alternatives that I think ultimately will really improve the system.
If I can make a comment on Chris's presentation.
Are you going to correct my description of your study?
No. It was accurate. What I thought was most heartening about that is that FLITSI was actually willing to be receptive to the academic research. And they wind up changing their training programs as a result of, in essence, having convinced themselves by partnering in an experiment that one procedure is better than another. And my experience is that it's easier to work with the federal investigators, either because they're more talented or they're more receptive to the science or they feel less threatened by the research community, which what I take as part of our job is to critique what's currently being done if we think there are better ways to do it. My experience is that the local police feel more threatened than the federal investigators. But even within the local police, some are more progressive than others. And not surprisingly, the more progressive ones are more sensitive to and the more receptive and more open to the science that comes out. And so they wind up leading the way.
Thank you. So now we'll open up the discussion. I think some of our discussion topics were definitely covered in that initial segment. So thank you so much for all your comments. So just to get started, I'll start with you, Ron. What are the goals of cooperative witness interviewing, and what are the current practices and the ways that those sort of don't meet those goals?
Well, as I alluded to before, I think that typical current practices are getting witnesses to become question answers. So investigator asks a question, the witness answers the question, which I take is a very inefficient method of getting information from people. Part of it because it's being directed by somebody else. Part of it because it restricts people to only answering the question and not volunteering other information. I can't tell you how many times police officers get frustrated because they'll interview somebody who will give them a limited amount of information, and then another police officer will get additional information. And the police officer will say to the witness, well, why didn't you tell me that? Well, because you never asked, as if the only thing I'm supposed to do is answer your questions. And I see that as, in overview, one of the major limitations of investigative interviews is that they convert people who have a lot of information into question answerers rather than information generators. And I see this not only in police interviews, but in virtually all of these interviews that are being conducted by lots of investigators, including your physician, including attorney interviews, including accident investigators. They all take the same model of, let me just direct the interview toward what I need to find out, as if I know all of the information that I need to find out, and you can't possibly tell me anything that I haven't already thought about. So our goal is to try to get as much information as possible by convincing witnesses that it's their job to inform us about what they know, and that we're there mainly just to guide their recollection as opposed to trying to pull out the information from them, obviously also trying to minimize error. But if you allow people just to tell you what they know without trying to pull out information from them, you get relatively little error. Memory, for the most part, works reasonably well, despite all of the research studies that you see showing that people make lots of mistakes. Well, people make lots of mistakes in these research studies because psychologists are smart and we can figure out how can we trick people by asking them bizarre kinds of questions. But if you actually ask people just to tell you what they know, for the most part, they're very accurate.
Thank you. Dr. Meissner, can you talk a little bit about specifically what the current practices are in terms of suspect interviewing that sort of are currently being reformed?
Yeah. So my colleagues and I often refer to this as an accusatorial model. It's a model that looks to leverage pressure points, create stress and anxiety. It's a model that's based on interpreting that stress and anxiety as signs of deception. And it's, as I think Steve eloquently describes, is on the forcing side of that continuum between forcing and fostering. The accusatorial approach tends to involve an initial interview in which the investigator is taught to ask some general questions and some probative questions that offer them an opportunity to evaluate deception. And at times those probative questions are evidence-based, so one might be called the bait question, in which evidence might be asked about. Other questions have to do with guilty knowledge in the state of the state of mind of the suspect. But it's a situation in which the investigator is attempting to assess credibility, and upon a determination of this person's not being forthcoming with me, they must be then guilty and have guilty knowledge, the interrogation phase commences. And that interrogation phase, we like to describe it as kind of a 3-step phase. It's taught in some schoolhouses as 10 steps or 8 steps, but you can kind of boil it down to 3. The first has to do with isolation and kind of separating the suspect from other sources of social support so that the interrogator becomes that one person that they can talk to. The second phase is really about confrontation. And so this is when anxieties are ramped up. The suspect is confronted with their alleged guilt, with evidence. I think all of you sitting in the room probably understand that police don't have to be truthful about what they say about the evidence. They often will fabricate and exaggerate. We call that maximization. They will maximize the suspect's perception of the evidence and maximize their perception of their own guilt. In other words, they want to create a situation in which there's no way out of this room but to confess. And the third phase is what we might call minimization. It's when the investigator opens the door and offers alternatives for why the crime occurred and attempts to assuage the guilt of the suspect. And so they may say, attempt to kind of minimize their culpability. This was an accident. You didn't mean to do this. This just happened. You were at the wrong place in the wrong time. They'll also minimize indirectly, they can't do this explicitly, but indirectly, the suspect's perceptions of the likely consequences associated with confession. And they can do that through, I've got some wonderful videos in which, they'll kind of offer alternative questions. Were you a monster, or was this just a mistake? Right? Listen, if you talk with me, I know the judge, I know the prosecutor. I'm going to be there with you. I'll go to bat for you. Listen, we can make this all go away, but I need for you to come clean and tell me what happened. And so there's an implication of leniency. There's an implication that if you confess to the more egregious crime, the stakes are very high. But there's an alternative option and a way to confess. The problem with this method, of course, is that it is coercive. It's psychologically coercive. It does achieve and succeed in getting guilty suspects to confess. Unfortunately, it also increases significantly the likelihood that innocent people will feel as though the only way out of that interrogation room is to confess. And in fact, in studies, experimental studies that we do and others do, it increases the false confession rate by 2.5 times. So it puts innocent people at significant risk. And therein, as I mentioned before, it reduces the diagnosticity, if you will, of the evidence that you collect out of that. There's also the significant issue of contamination. I don't know how many of you have read Brandon Garrett's book on wrongful conviction. He has a wonderful chapter in there where he talks about the 40 false confessions and the problem of contamination. If you haven't read it, I encourage you to read that. I don't know how many of you have watched the Making a Murderer series. I was at Duke about a month ago with Laura Neryder. We were doing kind of a 1-2 punch, and she led talking about the Dassey case. And she's got a wonderful set of videos, she and Steve Drizzen, looking at these techniques, these accusatorial techniques. In fact, you can see their talk. It's on YouTube. They've done a wonderful, almost 2-hour presentation on this. But one of the sets of clips that I found most interesting was that in the Dassey case, they had 3 pieces of information that had been withheld from the news and the public that they wanted to get Brendan to admit to. And I think this started out really well-intentioned. This is a way for us to validate his knowledge of the crime. It's crime-relevant knowledge. Only a person that was there would know these facts. And what's amazing about these clips that they've kind of strung together is the extent to which they move from kind of open-ended questions to more pointed questions to very suggestive questions to ultimately, one of the pieces of evidence was how the victim was killed specifically. And so ultimately they get so frustrated, they start to suggest specifics to Brendan. And you can tell he's guessing all along the way. But ultimately he gives them the right answer. Well, it was this. And they look at Brendan and they kind of say this, why didn't you tell us that to begin with? Well, had the investigators thought for just a little bit, there's a good reason why he didn't say that at the beginning, because he didn't really have that knowledge. And all along and through these 3 pieces of information, they essentially had to feed him the information. And they contaminated that confession ultimately. So I hope that's a good description of kind of existing practice, and I know we'll kind of get in as we go along to what the science is finding as an alternative.
And Colonel Kleinman, what are the existing practices in sort of military interrogations that necessitate the needs for reform?
Oh, wow. I think the military interrogation experience writ large and how it can shape the reformation of criminal justice is to ignore it completely. I mean, honestly, let me put it in context here. In terms of our technical intelligence capability in this country, it's really unrivaled. Our ability to collect signals, to exploit the electromagnetic spectrum, to create images under any weather condition, and sometimes even ground-penetrating radar. It's unrivaled. It's amazing. And there are 2 elements to it. It's science-based. I mean, mathematics, computer science, physics is at the forefront. And because of that, because of the complexity, there's very few questions asked, certainly by policymakers who, as I think Stephen Penrod would said, forgive me, but many people out there are refugees from numbers, otherwise very bright people, and somehow they didn't like numbers and it shied them away from science. So they don't ask questions. They just assume that the person in the proverbial lab coat, they know the answer. But there's no real social influence. There's no television shows that go into great detail. Conversely, you have interrogation, which the state of interrogation in this country is decidedly unscientific. It's certainly not informed by what we know about science. But curiously, there's also no questions asked because there's that ubiquitous portrayal, fictional portrayal of interrogation. So you have people at the highest level, at the highest policy-making levels, who determine everything's fine. You know, that's the way I would do it. Because why? Because they saw that on television. I had the really interesting, I won't say dubious, but interesting experience of testifying before 5 different congressional committees. And I heard a lot of the same questions. And I literally heard members of Congress cite that television show 24 to support the idea that we needed to be more forceful with terrorists because they saved the day. And my response was, then if you need major surgery of some sort, there's all sorts of medical television shows we could refer to, but I wouldn't recommend it. But again, is there science? Can we explain? Can we justify? Absolutely, when you're putting together a satellite. But for some reason, there's just the acceptance that we know how to do this, even though just a shallow dive into, again, that Army field manual on interrogation. And I mention that again because it is the law of the land beyond the military about how we conduct interviews and interrogations at the federal level. But without a scientific, without an objective, without empirical evidence, we're putting a lot at risk. And the same holds true in interrogations and interviews that are conducted in the criminal justice system. Not surprisingly, there's many, many people, a large number of individuals in law enforcement have military backgrounds. You know, it sort of attracts the same demographic. I mean, there's a lot of similarities in culture. And the problem lies with, as you move up, either through the military ranks or through law enforcement, and interrogation is part of your skill set, so to speak. And when you get to a certain level, you are recognized as an expert, and nobody challenges you. That's a problem. But what makes it more insidious is when you need those people to embrace change. For example, some of the top experts, in quotation marks, in the military on interrogation are experts because they know the Army field manual better than anybody else. So how easy is it to facilitate change when you need people to admit that, you know, yeah, I need to give up my position as an expert because the underpinning, the foundational knowledge is actually not knowledge at all. It was conjecture passed on by tradition and turns out to be counterproductive. It's not easy for those people to give up. God, I like to properly cite my quotations, and it escapes me right now, but a great one about how difficult it is to convince somebody to change their mind when not changing it, you know, they're paid essentially, their living depends on their ability not to change. So what we see in the military is exactly the same. So we need to think about, how do you introduce innovation? And there's a lot of work in behavioral science about how ideas come to pass, how creativity leads to innovation that leads to application. And you know, we have the S-curve, early adopters, and then you have the masses, and finally the people that are only change kicking and screaming. So there's a lot of parallels, that the same challenges exist, the same opportunities exist, the same purpose, and that is to get the best possible, most complete, most accurate information from people that can change how we understand the world around us.
Can I interrupt for a second just to ask Steve a question? Because I want to make a point here. Steve's again too modest to talk about the impact that he's having on the training academy and on state and local law enforcement, and the champions he's developing that are actually looking for change. And I guess I just want to ask you, Steve, your perception here, the S-curve. Where are we on the S-curve in state and local law enforcement, federal law enforcement versus Army field manual military interrogations?
Wow.
Where do you think we are?
Yeah, that's a good question. As Ron mentioned, there are pockets of real progressive thinkers out there, but they are still the outliers. They are still the outliers. I think at the federal level, for the most part, we're still, we're still in the early adoption phase at best. In some places, it still hadn't even entered into the S-curve, honestly. We will, Chris and I do a lot of training together. We will present to various audiences, and you start to see a statistical pattern develop that's consistent across audiences. There are those who take a very professional approach. This is what I'm doing with my life. Like, I'm an investigator. This is what I'm doing. I want to be best at it, which means sometimes I need to give up what I know for the possibility of what I can learn. And they're the ones staying after class and asking questions and stay in touch and want citations and actually read the research and share their successes and their challenges. And they had the other ones who just from the beginning, they kind of, there's nothing, he's an academic, he can't teach. You're an intelligence officer, you've never conducted an investigation, you have nothing you can teach us. And so it's very uneven, but I will suggest this though, and I really truly believe this, that the ideas that the community, that the research community has to offer to the criminal justice system, and to my old world, the intelligence community, but certainly the criminal justice system, about how you collect, how you use, how you analyze, how you assess information is so disruptive and so constructive that S-curve is going, I think the community, the law enforcement community, is going to move through that very quickly, and at some point that those who are still using the outdated model will be ridiculed and diminished as throwbacks to an older era.
Yeah, and the challenges that we've had, we both sit on the Higg Research Committee, and we will often talk with the Higg about their influence on, part of the McCain-Feinstein Amendment was not only to make the Army Field Manual the rule of law, but the amendment also included language around the science that the Higg is producing. And it required the Higg to generate summaries and provide to Congress and other agencies summaries of the research. And it required the Army Field Manual to be updated every how many years? I can't remember.
Yeah.
Every number of years, 2, 3, can't remember. And one of the sticking points in that legislation, the language, was around whether that update needed to reflect the science.
Yeah. One of the questions that I would ask is, why are some cultures more receptive to, let's say especially the interrogation and investigation, that some cultures seem to, at least from my perspective, seem to be much more receptive to the science than others. So I found working with either the Canadians or the British or the Israeli or the Australians that they are much more receptive to the input of the sciences than the Americans. And I'm not quite sure why. So one of the differences that I see is that in all of those cultures that seem to be more receptive to the science, you have people who are practitioners going through the university. And a lot of them will get a master's degree, or they might even get a PhD, and then they go back to their own practitioner community. And I think that helps to bridge the gap between the research community and the practitioners, that they have become intimately involved in the research themselves. And I think in the United States that there's an antipathy between the research community and the practitioners, and they can't tell me what to do. And if I want to learn how to become an investigator, I'll stick with the police or the Army rather than see what I might learn from this other institution. So if you want to change globally, somehow or other you're going to have to change the interaction between the scientific community and the practitioner community. I mean, one of the things that I've always been frustrated with is that I think that there's not enough of an exchange between the two. And it's not as if this is a one-way street. It's not like the researchers can tell the practitioners something, but we can't learn something from the practitioners. From us, the practitioners have a lot of experience that we simply cannot duplicate in the laboratory, in large part because we're prohibited from conducting experiments where we put people in harm's way. But when these things happen naturally in the streets, if we would get involved in those kinds of investigations, if we would expand our own opportunities. So it seems to me that it's really a win-win situation if somehow or other we could figure out how to bridge the relationship between the research community and the practitioner community, which I see is one of the major differences between those cultures where the practitioners do take advantage of the scientific community and the scientific community takes advantage of the practitioners. How do we get to their stage as opposed to what I see as a very cold relationship in the United States?
I think those are you're right on. When we first started working with the HIG, and we would kind of travel to training academies and meet with law enforcement, I mentioned that most of my research early on was on false confessions. And I remember very vividly giving a talk at FLETC and talking with some of the trainers that were in the room. It was a room this size, but absolutely filled with trainers from all over. And talking with a few of the trainers afterwards, they said, you know what, Doc, I expected you to talk about false confessions because I've seen your work with Saul Kassin and others, and I know that you're a critic of these methods, but you didn't come out here blaming us for the problems and scolding us for the problem of false confessions. In fact, your message was more of a positive message, and how can we collaborate and work together? Mm-hmm. I think the real divide, we kind of set up as academics to be the critics. We study errors. As psychologists, we love to study errors. We're really good at studying why people do things wrong. That's easy, though. That's actually the easy work. The hard work is actually learning what they do and trying to develop ways to help them. And that requires collaboration. That requires us spending time with them, learning from them, learning their vernacular, their vocabulary, the way they see the world, what the process is like. So, you know, the first 4 years of the HIG program, I remember going with the research director and traveling to training academies, and we wouldn't bring an agenda. We would literally sit in the back of trainings, and we would be there to talk with them. We wouldn't tell them how they should be training. We wouldn't tell them what they're doing wrong. We were there to learn from them, and we were offering collaboration. And it took quite a while to develop that trust and relationship with them, so that when we wanted to do a study with Ron at FLETC, FLETC by that time was now bought into it and willing, because we had gone to FLETC not with an agenda, but with an interest in kind of learning what they do and with a message of trying to help them.
And I think that sometimes academics are a little bit too haughty, just a little bit though, and that we think that we have access to all of the knowledge and that practitioners can learn from us, but we can't learn from the practitioners. When we started doing the work to develop the cognitive interview, so we listened to literally dozens or maybe hundreds of police interviews with witnesses, and we learned from them. There were clearly differences between very effective interviewers and poor interviewers. So if you model what the very effective interviewers do differently from the poor interviewers, so you get some insights about what will work, even if we don't have necessarily a very good theoretical model, a good psychological model as why does this technique work, why does this other technique work, we could still learn from them. So then to follow that up, when we found really effective interviewers, so I would speak to them and ask them, well, what's your strategy about interviewing witnesses? But I don't want to say, well, I think I have some insights that the practitioners don't, but they have some insights that we don't also, and that in general, it would be a much more effective communication if we both learn from each other. Mm-hmm. But that's why you need symposia like this, where you have combinations of practitioners and the academics.
Mm-hmm. Thank you. That was a really great discussion. I don't want to go too far in this symposium or in this panel without sort of maybe being a little more specific about some of these techniques that are these reforms. So I'll start with you, Dr. Fisher. Can you just sort of walk us through the cognitive interview, what it entails, what the procedure is?
In 3 minutes, right?
Well.
Yeah. So much of it has to do with establishing the appropriate social dynamics. As I mentioned before, that you have a starting point, which is a very inefficient way to gather information, where you have a conversation. It's not really a conversation, it's one person trying to draw out information from another, which itself is very efficient. But it kind of lends itself to the difference in social status between the police officer and the witness. So at some level, you have to convince the police officer, even though he or she has a lot more power and is dressed for power, that they're wearing a uniform, they represent the government, and they have a gun. Well, maybe everybody has a gun now. That they're there not to pull out information. They're not there to use their power. They're there to, and you have to kind of change the social dynamics to convince the police officer that he or she is supposed to be a listener and a facilitator of the witness, and that the witness's job, even though the witness is speaking to somebody who has a lot more power, that the witness is supposed to play an active role. And witnesses, partially because they watch television, where interviews on television are very misrepresentative of what happens in the real world, where the interview takes maybe 10 seconds on television, and the star of the show is always the police officer, and the witness always plays a bit role. So naturally, witnesses use that as their model, so they assume that they should play a bit role, and that the star of the interview is the police officer, and that the whole interview is only going to take a few seconds, and that because the police officer is so smart, that they will solve the crime, even if you provide very little information. But part of it is that you have to start off establishing the appropriate social dynamics of who has the information. Namely, it's the witness who has the information, and that should be guiding the interview. So that's part of it. And then this whole issue of developing rapport, which is one of the big differences between really effective interviewers and poor interviewers. That very effective interviewers present themselves as human beings who are concerned about the plight of the person that they are speaking to. Especially when speaking to victims, they present themselves as human beings, as if they were talking to a family member who is primarily concerned about what have you gone through. And other interviewers, who tend to be much less effective, treat the person only as a repository of information. You know how tall the person was, you know what the gun looked like, you know, and I'm going to get all that information from you. But the interviewer then treats the person only as a source of information, but not as a person who's gone through a terrible ordeal. So part of it is training interviewers to become much more receptive to the respondent as a human being, and to share experiences that put them almost on equal status. And then there are issues related to memory, issues related to general cognition. For instance, well, some of you may be doing this now, but we know that if you close your eyes, you're actually become a better rememberer. If you ask people a difficult question, so they tend not to look at you when they answer that question. So if I ask you who is the 22nd president of the United States, I don't know, but if I ask you that question, you would probably look away. Why? Because it allows you to concentrate better. So if people naturally do that in order to concentrate better, why don't we just encourage them to do that? If I make direct eye contact with you, I encourage you to look at me. So if you're looking at me, you're going to be thinking about me, but as the interviewer, I don't want you to be thinking about me. I want you to be thinking about the information that's in your head, but that means that I have to be out of the picture. This is not supposed to be a conversation between the interviewer and the respondent. If it's a conversation, then the conversational norms of making direct eye contact and focusing on the other person and not speaking too long, they will prevail. If those conversational norms prevail, witnesses will not be concentrating, they will limit their answers, and they'll give you relatively superficial descriptions, because that's what's acceptable in normal conversation. So part of the goal then is to convince people, and also to structure the interview so that this is seen as a search through memory, which is an isolated experience. It's not a social experience. That is, the goal is, how do we get the witness to concentrate so intensely so that he or she searches through memory as efficiently as possible, and where the interviewer plays a relatively secondary role and does not intrude himself or herself onto the consciousness of the witness. But that's completely different from what I see as typical in a police interview, where it's a conversation and the wrong person is dominating that conversation. One last comment on that. I think that interviewers restrict themselves too much to getting only verbal information, but there's a lot of nonverbal information that you could get from people, either, for example, by asking them to draw sketches, asking them to reenact what they experienced. And I see that this happens relatively infrequently. Even asking people to draw a sketch of what they were thinking about, which is obviously kind of an abstract sketch, even that works to entice people to provide more information. One last point, and then I'll give the floor to other people. Witnesses don't know, civilian witnesses don't know how much information police need. So they make an assumption that this is a casual conversation, the same conversation that they've had with their neighbors, and you're not supposed to give very detailed descriptions. If you ask your neighbor, how was your vacation, and your neighbor takes a half hour to describe your vacation, you will probably never speak to that person again. So people are in the habit of giving 20-second responses because that's appropriate in casual conversation. Unless the witness realizes that the interview is not a casual conversation, the witness will fall back to conversational norms, which is to describe things in relatively minimal detail, to give relatively short, brief descriptions. And so you need to somehow or other educate witnesses that this is not a casual conversation. Here's the kind of response that I'm looking for. And then what I would do if I were the police officer or the interviewer is give a model statement of here's what your answer should sound like. And I would close my eyes and I would gesture a lot and I would give a very, very detailed description. So I've worked with a lot of investigative agencies like the military, and usually at the end of the training program, so we ask one of the trainees to interview somebody who works for that same institution but who wasn't part of the training program. And the trainee who's doing the interview starts off by saying, look, here's the kind of description that I'd like you to give. And then the interviewer provides a model of what it's supposed to sound like. And it works extremely effectively. So when they do this demonstration really at the end of the training program, and the respondent gives a really detailed description, like a 45-minute detailed description. So I asked the respondent in this exercise, well, that was a really detailed description that you gave me, and it was unusually detailed. What prompted you to give me such a detailed description? And invariably they say, well, because the interviewer gave me an example of what he or she wanted me to do. So I just copied that example. But had the interviewer not given an example of what an ideal statement is supposed to sound like, witnesses will just revert back to their conversational norms, which is clearly inappropriate for trying to elicit a detailed description. So it's kind of a combination, as I mentioned before, of facilitating communication, facilitating memory, facilitating the social dynamics.
Thank you. Actually, I'm going to take the moderator's prerogative and ask you a follow-up. So you've written a little bit about memory confabulation. How does that relate to the cognitive interview? How does the cognitive interview deal with, what is that, and how does the cognitive interview deal with it?
Well, there's a certain amount of confabulation that works its way into any conversation. If you were a witness and you say, I saw person A shoot person B, you didn't really see person A shoot you didn't see a bullet coming out of person A's gun and entering person B's body. You saw person A pull out a gun, you heard a noise, you saw person B fall down. You make the reasonable assumption, which I would call confabulation, just that it's a correct confabulation, that person A shot person B. But that's an interpretation of signals that you saw. Most of these interpretations are going to be correct. Most of the time when person A takes out a gun and there's a loud noise following and person B falls down, it's because A shoots B. But that's a confabulation. You didn't see a shooting. You just assumed, given all of the perceptual information that you had, that this is the explanation. So not all confabulations are incorrect. I would say that, again, if you allow people to describe what they saw, as opposed to what police often do, which is asking very, very specific questions, if you allow people to describe what they experienced, for the most part, their descriptions, some of which are confabulations, are accurate. So you have to make a distinction between confabulation as a process, that is, this is an inference that I made, versus confabulation being incorrect. Confabulations may well be correct.
Thank you. So Dr. Meissner, would you talk about specifically what are the sort of reformed interrogation techniques that take the place of sort of the previous ones?
Sure, yeah, and let me, I know we're limited on time, so I'm going to offer to send, we've written several reviews on the science and kind of condensed it into these boxes that I'll talk about. I'll send a couple of those papers to Amanda and John, and if you're interested and want to learn a little bit more, they can share those with you. So think about four primary processes that, psychological or otherwise, that interrogators engage in. One of them has to do with developing a relationship with the suspect. I want you to think about this for a minute. Think about something that you've done in your life that you're not very proud of. Something that you would feel ashamed to tell other people. Who would you be comfortable telling that to? The person next to you on the plane? The stranger that you meet on the street? Somebody that pulls you into a room and is purposefully asking about that? What are the conditions under which you're willing to talk about those things and would be comfortable doing so? I think we know from a lot of research that those secrets are released and shared in situations in which people have relationship, and there's trust and there's rapport. Now, trust and rapport, those are buzzwords, right? Turns out there's actually been quite a bit of research in the behavioral science literature and in the medical literature, for example, on how to develop rapport and what is rapport and how we can measure rapport. And trust, even in the economic literature, looking at trust and what is the concept of trust and how does trust develop. And so much of that theoretical literature is there. What we've done in the science is gone back to that theoretical literature and got a better handle on how do we measure rapport and trust, under what conditions or what processes are likely to bring that about, and can we study it systematically? And so we've actually, over the past 5 years, done experiments on ways, on techniques to develop rapport, quick rapport. And some of it is about, I'll give you a couple examples of tactics. One tactic is that, and by the way, anybody bought a car recently? Yeah? Do you remember that salesman experience? A lot of the tactics that the salesman used to get you comfortable, to facilitate you making that decision, those are tactics of developing rapport and relationship, and they're in the service of pulling money out of your wallet. Marketing folks know these tactics really well. Sales associates are trained in these tactics. In the context of an interview or an interrogation, one tactic is to get to know the individual in ways that allow you to do a couple of things. So the more that I get to know you, the more that I can do things like self-disclose information about me. And it turns out in the social science literature, when I disclose information to you, it has two effects. Number one, it makes you like me more because I'm disclosing personal information to you. But number two, it actually puts the burden back on you and makes you more likely to disclose personal information to me. So using self-disclosure as a way of facilitating liking and also breeding a context of disclosure, reciprocal disclosure, is actually quite effective. Another tactic in this context is shared identities. Steve sat across the table from generals and colonels in other countries who were nothing like him, right? And there's no way that they could have any shared values or identities or experiences, right? No, not right. In fact, they're both human. They both had a human experience. There are things that transcend culture. There are ways of connecting with people. If we can identify shared experiences, it brings us closer together, and it begins to build a relationship. So these tactics are really fundamental to social influence and social psychology and the kind of social psychology of relationship and developing rapport and trust. We now have a suite of tactics like this that allow interrogators not to just say, I gave him a bottle of water, but here's why and how I gave him a bottle of water. And here's what that led to, and here's what it allowed me to do in terms of getting to know him and make him feel comfortable, and to establish a cooperative context. And that's probably the most important point here. These tactics aren't being used to elicit a confession. They're being used to establish a context in which people are cooperative. The goal of this, remember Steve mentioned, if you change the goal of a system, you change the system. And part of this science is pointing to the need to change the goal. The goal needs to be cooperation and disclosure, not confession. Let me say that one more time. Cooperation and disclosure, not confession. And so the goal of these tactics, these rapport-building tactics, are not to get the person to confess to me and admit the crime, but the goal is to get them in a cooperative context where they're just willing to talk to me. And they're willing to tell me things that are right, and they're willing to tell me when my conjecture or my ideas are wrong, most importantly. Okay, that's box number one. Box two, Ron's already covered. It's on elicitation. If you've got a cooperative person, how do you get information out of them? Well, you've got to have good interviewing strategies. You've got to have good questioning strategies. A lot of that comes out of the research on eyewitness memory and good questioning. And as Steve underscored the point, where does the information lie? It lies in memory. Why don't we teach memory in the interrogation schools? Why is memory not important? In fact, it is. And we need to treat the evidence that we collect from suspects as carefully as we treat the evidence we collect from witnesses, or we should treat them equally carefully. So good questioning and proper elicitation in a cooperative context. We've moved them from resistant to cooperative, and now we're inviting them to tell us information. All right, box number three is evidence presentation. One of the most powerful predictors of confession is a suspect's perception of the evidence. Now, we also know that evidence presentation can go awry. In other words, it can lead to false confessions when evidence is exaggerated or falsely presented. And so one rule here is to stay away from fabricating, misleading, or falsely presenting evidence. But the rule is not to not present evidence. In fact, there's terrific research by Maria Hartwig and others, Per-Anders Granhag, Simon Oleszkiewicz, looking at how you present evidence truthfully, but systematically and persuasively. Because two rules that fall out of this. Number one, hold your cards. Present the evidence late in the investigation, not early, or in the interrogation. Late, not early. And number two, systematically present your evidence from weakest to strongest. Think carefully about how you present that evidence in ways that begin to box the suspect in to inconsistencies in their narrative and to information they haven't provided but which you have, right? So there are very good evidence-based techniques to presenting evidence in ways that motivate confession and help us to separate the guilty from the innocent. Box number 4, last one, detecting deception. The prevailing doctrine in the field has been that deception is marked by nonverbals and anxiety, physiological responses. 3+ decades of research looking at that particular model doesn't really support it. There are many reasons, any of us, okay, here's my example. I travel internationally quite a bit. I come back through customs. I present to the customs officer. I have no reason to be nervous. No reason. But somehow, no reason, but somehow that experience always makes me nervous. It really was business. It wasn't pleasure. Oh, wait a minute, I did a little bit of both. I don't know. Yeah, I think I gave you everything on that list that I purchased. I might have forgot that candy bar, though. Am I going to get in trouble for that candy bar? I'm nervous. I have nothing to be nervous. I'm completely innocent. I'm acting within the law, and yet that interaction makes me nervous. Is nervousness a sign of guilt? No, it's a sign of nervousness. It's brought about by the situation. So we've got to move beyond that. And this is where Ron Fisher, Albert Vrij, and others have begun to create and offer us a better model of how to assess credibility. And it's all in the way that people tell their stories. It's all in the cognition, the cognitive processes that involve lying versus truth-telling. It's the cues that are present in the way that people tell their stories. It's the cognitive operations that are different. Just one example. Lying is difficult. Lying is like juggling 10 balls compared to truth-telling. Because you've got to, number one, suppress the truth. That actually surprisingly takes effort. Number two, you've got to create a narrative. Number three, you've got to provide that narrative consistently and convincingly. Number four, you've got to monitor whether you're being believed. Number five, you've got to control your own behavior so that you're acting like a truthful person. You're doing many things, and we call it cognitive load. You're under significant cognitive load. Your executive function is off the charts when you're lying. When you're truth-telling, it's about memory and telling your story. And so cognitive load is actually reduced compared with liars. Well, we can take advantage of that. And Ron and Aldert and others have developed techniques that allow us to separate liars and truth-tellers. They're interviewing techniques that allow us to separate liars and truth-tellers with much greater accuracy than focusing on nonverbals. We do a lot of meta-analyses. Ron mentioned this. We recently did a meta-analysis on training to detect deception. And it turns out these are randomized controlled studies that look at training effects in different ways. And it turns out if you focus people on the verbal cues, the story, the narrative that people tell, you can significantly increase people's detection abilities as compared to focusing them on the nonverbals and the anxiety cues and other things, which tend to be non-diagnostic. And by the way, the other thing I like to say is the best way to tell whether somebody's lying or telling the truth is to shut your eyes and listen to them. We find systematically in studies that when people are presented auditory tapes versus videotapes, it's systematically better when they listen than when they watch. Because the best cues are in the way that people tell their stories. All right, last thing that kind of overrides all four of those is the mindset of the interrogator. Something that we haven't really talked about is this role of investigative bias or belief in the guilt of the suspect. Oftentimes, suspects are interviewed at times when police have a firm belief in guilt. The suspect has been nominated. They've increased their perception of the guilt of this suspect. And that guilt, that belief in guilt, actually changes the way that they conduct the interrogation. They ask more guilt-presumptive questions. They conduct longer interrogations, more pressure-filled, more coercive, and they don't give up until they confirm their belief in guilt. We've got to change the mindset of how police investigators approach a suspect interview. It's an important part of it, and it sets kind of it influences each of these, how they develop trust and rapport, how they elicit information to avoid contamination, guilt-presumptive questioning, how they present their evidence, when they present their evidence, and how they assess credibility. That mindset affects each of those processes. Again, I know we are limited in time, so I'll pass a couple of papers if you want to read a little bit more.
Great, thank you. And Colonel Kleinman, I was wondering if you could talk a little bit about the specific techniques used to reform military interrogations and how they differ, if they do differ, from criminal justice investigations.
Yeah, Chris and I wrote a paper about this the other day. We'll give you more papers, like you don't have enough to read. But there's far more parallels and and synergies, if you will, between how information is elicited, because that's fundamentally what it's about. Now, you have standards of evidence, you have criminal procedure that governs interrogations in the criminal justice context, obviously. But what Chris has just outlined is exactly probably the most ideal model that we can yet create to elicit useful information. And in both cases, it comes down to really two fundamental tasks. Number one, you have to manage strategically the relationship that you have with that individual towards the purpose of cooperation. At the same time, recognizing it's a competitive exchange of information, almost a negotiation. Thus, you get to the final step of disclosure. And again, in both criminal justice and intelligence, those are really preceded sometimes. In fact, it depends on the circumstance, perhaps frequently, by two other challenges beyond cooperation disclosure. Sometimes the first step is just getting somebody's attention, that they're actually attending to what you say. Two friends of ours, Bob McFadden with NCIS and Ali Safan from the FBI, they were interrogating Abu Jandal, who is allegedly bin Laden's bodyguard / driver. And there were days when they would walk in the room and he would just turn his back. And so their first challenge was certainly not to get him to disclose anything. They were far from that. And cooperation was still in the distance. It was literally finding something to get that person to pay attention. And they came up with a very clever, very thoughtful approach. It was really about the person's being diabetic and providing sugar-free cookies and understanding the names that his mother used for him as a child. It was perspective taking. It was, instead of Ali and Robert going after this, well, this is what I would respond to. It was adopting that individual's cognitive perspective and showing a great deal of empathy. So it's fundamentally understanding that there's an information cycle, there's a relationship cycle, and you put those almost like strands of DNA onto those four different tasks of attention. Then the next one is engagement. I mean, they're not disclosing information, but there's turn taking in a conversation, and they adopt that. There's a certain attending to you and what you say. You ask questions. You ask them to, sit down, or would you like a cup of tea, and they respond. So you're getting a certain amount of engagement that not yet what you would characterize as cooperation. But those are these overlapping spirals, if you will. The traditional way of interrogation that still occurs in many places today, both in military and criminal justice system, sees it as this linear step-by-step process, always moving forward, these phases. And they're independent. They're just in order, but they're almost independent. Like establishing rapport, okay, I got rapport, now I'm going to go into questioning with a very, very different demeanor, as if the individual is not going to recognize you went from being a therapist to Joe Friday from Dragnet. It's a complex adaptive system. How I would interrogate, like sitting talking to Ali Imran, one of the Bali bombers, how I would engage with them is different than Ali Safan, who was also with me, because we're different people. These emergent properties occur because of my life experience interacting with their life experience, my expectations, my hopes, my objectives, interacting with, sometimes conflicting with, but hopefully engaging with their hopes and dreams and aspirations in the moment. So and it depends on the topic. There's some people can be very, very cooperative about topic X, and they immediately go to cooperation disclosure. But yet, there could be something else. It maybe involves a family member. Maybe it involves something that they find more embarrassing. Maybe it's something that they feel there's a higher consequence that's attached to it, that you can barely get their attention on it. Certainly, not their engagement, and certainly not cooperation and disclosure. And it's important to understand those differences, because during the first Iraq War, we had people who came across the border in response to psychological operation drops, and they were very, very open about the structure of their infantry unit, for example. But when we got to location, they were very sketchy on the details. And most interrogators thought, well, they don't know anything more because they've been very cooperative about the structure and the function of their unit, but So why would they lie now? Well, they lied. They defended the fact that some of their friends, some of their brothers, some members of their tribe were back there, and they knew that if they gave us the information, there's a good chance that B-52s would apply kinetic energy in 24 hours. So, and going to the criminal justice system the same way. There's different areas that people are going to be willing to be cooperative and disclose, and other areas are going to be very, very resistant and evasive. So understanding that spiral, and I guess the fundamental lesson that I would share with the criminal justice system, when a person, and that is this, you can never not do something. I mean, that sounds like really, really awkward English, I understand that, but you can never not do something. If you decide, well, I'm not going to do anything, I'm not going to walk in the room, that is doing something. They're waiting for you. They're thinking, what's going on? Are they getting more evidence on me? Is there a new witness? Is there something? You are affecting it. You walk in and sit down. They're going to look how you're dressed. They're going to look at your gender, your ethnicity, everything, how you speak to them. And so that it's this, and you're going to draw out, you're going to elicit certain responses that you have to be able to manage appropriately. And as Chris talked about, one of the mindset is always keeping that investigative or intelligence, or maybe generically, that exploratory mindset, that you're comfortable with ambiguity, you're comfortable with uncertainty, and that your every move, your every word, your every gesture is shaped by one fundamental goal, and that is to find the truth of the matter, not your truth. All right, let me put it another way, to find what is true, not your truth. My truth is that you're a fill-in-the-blank, disparative remark, and you've committed this crime. I want to find what is true. And that's a pretty noble undertaking.
Thank you. I think we are probably not going to have time for questions. Okay, we can do one. One question, what advice, if any, can you provide prosecutors when they are faced with cases where there has been a bad interrogation? In cases when you have a real victim versus a victim that made a false report, the prosecutor is faced with issues that must be addressed. So they're asking for some practical takeaway. So whoever wants to offer something.
So I'll just say, I like speaking to prosecutors. I like informing them about best practice and the challenges of collecting this evidence. I want to make them better assessors of the evidence that they have. And I think it's easy to just look at a confession, to look at a statement from a witness or victim and say, well, it's been collected. I don't need to worry so much about the process by which it was collected. I just need the outcome. And I think what I would encourage prosecutors to do is to begin looking more at the process by which that evidence is collected, and to understand the challenges and the pitfalls, the potential pitfalls that will allow you an in to assess the credibility of that. And one of the keys is even just looking at contamination. This is back to Brandon Garrett's book. If you understand who first proffered the evidence and whether that evidence came from the investigator offering it to the suspect who then repeated it, or it came first from the suspect of his own or her own volition, I think even that kind of analysis of being able to review the process by which that evidence was collected will give you an insight into some of the credibility of that. Looking at the context of pressure and coercion that might have led to certain remarks, or the shaping of the statement ultimately, will give you insight into the credibility of that evidence. And the same goes for, I think, victim and witness interviews. Good interviews give you more information about diagnostic assessments of credibility. Bad interviews should lead you to initially devalue the credibility or utility of that evidence. And what we'd like to do is change the system so that you have good interviews that allow you better opportunities to then assess credibility. Ron, I saw you leaning in.
A quick comment mainly on cooperative witnesses. So cooperative witnesses are going to remember some things incorrectly, in part because the memory system, it's not a perfect machine. whenever you try to remember and describe anything in detail, there will always be some errors. And you simply cannot avoid. The only way to avoid errors is not to conduct an interview. Once you decide to conduct an interview and you're asking for detailed information, there will always be some mistakes. So then you have two choices now. Should you make those mistakes available to defense and jury and try to explain them away by saying people are not perfect rememberers, but the rest of the information is very likely to be accurate? Or should you hide that information? Well, it partially depends on what's your goal. If your goal is to win the argument, you're probably better off hiding that information. If your goal is to provide as much information as possible and try to explain to the jury why this information, even though it's technically wrong, does not discredit the rest of the testimony, then you should make that information available. So it largely depends on what your goal is.
May I? In the interest of procedural justice, I think it's important to look at, we're talking about interviews as part of a larger system. It's not a standalone. And fortunately, we're working with a lot of prosecutors who attend the course and understand that there's a new process in town, so to speak, about how information is being collected, which enables them to leverage that information more credibly before a jury. Because I would argue, and I'm way outside my field, and I probably shouldn't be saying this, but I will anyway, I think procedural justice is based not on the confidence that the elements of a crime were fully established, but more so how those elements, how the evidence was obtained to support those elements. Yeah, especially when related to, was it the result of an interview? And by having both the investigators and the prosecutors on board with understanding, having an understanding of the behavioral science that underpins it, how, not just did they get the information, but how it was obtained. Because again, just like interrogation, as I mentioned, is a complex adaptive system, the criminal justice enterprise is a system as well.
Thank you so much. I'm sorry, I think we're out of time, but I've had a lot of excellent questions here, so I'm going to offer, without their permission, all of the panelists to speak to them some other time. But thank you all so much for being here. This was a really excellent discussion.
Thank you. Thank you.